Hi, everyone. Good morning. Welcome to this Crown seminar from the Crown Center for Middle East Studies at Brandeis University. We're very excited today to be joined by two of the foremost scholars of the Middle East working at the intersection of humanitarianism, law, and politics. Ilana Feldman is professor of anthropology, history, and international affairs at George Washington University. Her research is focused on the Palestinian experience, both inside and outside of historic Palestine, examining practices of government, humanitarianism, policing, displacement, and citizenship. Her first two books, Governing Gaza, Bureaucracy and Authority, and the Work of Rule from 1917 to 1967, published in 2008 by Duke University Press, and Police Encounters, Security and Surveillance in Gaza Under Egyptian Rule, published by Stanford in 2015. Both explore the dynamics of governance in unsettled spaces of the Gaza Strip. And more recently, her research on Palestinian displacement in the dynamics of refugee living with and against humanitarian assistance in different contexts has resulted in numerous articles and an award-winning book called Life Lived in Relief: Humanitarian Predicaments and Palestinian Refugee Politics by the University of California in 2018. She will be in conversation with Arzoo Osanloo, who is professor in the Department of Law, Societies, and Justice at the University of Washington. Professor Osanloo also holds adjunct appointments in the School of Law and the Departments of Anthropology, Near Eastern Languages and Civilizations, Gender, Women, and Women's and Sexuality Studies, and Comparative Religion. In addition to being a former immigration and asylum refugee lawyer, her research includes women's rights, human rights, and humanitarianism. Her first project, based on extensive ethnographic research in Iran, explored the politicization of rights talk and women's subjectivities in post-revolutionary Iran, and resulted in the book The Politics of Women's Rights in Iran by Princeton University Press in 2009. Her latest book, Forgiveness Work: Mercy, Law, and Victims' Rights in Iran, also published by Princeton in 2020, looks at the Islamic mandate of forgiveness, compassion, and mercy in Iran's criminal sanctioning system, Islamic scholarship, and everyday acts of pious Muslims. More recently, she has co-edited the volume Care in a Time of Humanitarianism: Stories of Refugee Aid and Repair in the Global South, by Berghahn Books in 2024. Thank you so much for being here today. And we really feel so lucky to have you. And Professor Osanloo, thank you. You're coming to us from Seattle, so it's extra early for you. Before turning it over to Professor Feldman, I just want to briefly introduce the format. Professor Feldman will start us off with a brief presentation. Following this, she and Professor Osanloo will speak for about 30 minutes on the topic. Then at approximately 11:45, Professor Osanloo will moderate a 30-minute Q&A with you, our audience. If you have any questions for our guests at any point in today's seminar, please use the Q&A feature on the bottom of your Zoom screen to pose the questions to our speakers. This discussion is being recorded and will become available on the Crown website. So without further delay, Professor Feldman, I turn it over to you.
Thank you so much. I'm really grateful for the invitation. I'm really looking forward to being in conversation with you, Arzoo. So I will try to keep my opening comments to time so that we really have the extended time for the conversation. So I guess to start, I think we have to note that over the past year, international humanitarian law, I think in some sense, is more present to many of us than it has been, certainly in a long time, perhaps ever before, but also at the same time is more clearly, seems more clearly impotent and unable to reach its aims than ever before. The Israeli war on Gaza that began after the Hamas attack on Israel on October 7th, 2023, has made humanitarian law a subject of intense debate around the world. So there are efforts to use international law instruments and institutions, notably at the International Court of Justice, also the International Criminal Court. These efforts to try to use these instruments to alter the shape and character of the war have had little immediate impact, but they may reshape international law. And I think that Palestine's place as a crucial cauldron for understanding how humanitarian law operates and what sorts of life-making happened under this law predates this war and will certainly extend beyond it. So in relation to Palestine generally and Gaza specifically, there are at least three aspects of humanitarian law that are most relevant and resonant. The first is refugee law, because so much of the Palestinian population are refugees as a result of the 1948 war, which established Israel and displaced around 750,000 Palestinians. About 200,000 of these displaced people went to the Gaza Strip, which we should also note is itself a product of the 1948 war and the armistice agreements which demarcated boundaries at the conclusion of active fighting. So almost in the current moment, so you have a population that is 2/3 refugees, and at the current moment, almost the entirety of Gaza's population is internally displaced. And the possibility of mass displacement from Gaza still looms quite large. So refugee law may have a sort of returning different kind of relevance. So the second relevant area of law is the law of belligerent occupation, which is part of international humanitarian law, and which delineates specific obligations of occupying powers. And this, of course, is relevant because Israel occupied the West Bank and Gaza, along with the Sinai and Golan Heights, in the June 1967 war. And IHL outlined some fairly specific obligations for occupying powers, which include the prohibition on the forcible movement of occupied people from the territory, a prohibition on the transfer of occupying populations into the territory, prohibition on collective punishment, and an insistence that the occupying power must ensure access to healthcare and food. So all of these questions are deeply relevant at the current moment. And then the third aspect of humanitarian law that I want to touch on are the IHL, LOAC, which is the law of armed conflict. IHL and LOAC are basically two words for the same area of law, the provisions on the conduct of warfare. And this is obviously relevant because of the war in Gaza right now. LOAC has principles such as distinction, proportionality, military necessity, limiting unnecessary suffering. And we can talk about these as our conversation goes on. One thing that I think is crucial to note at the outset about all these provisions, IHL provisions on the conduct of war, they are non-reciprocal, meaning that a state's obligations to follow the laws of war is not dependent on their adversary following the laws, right? So the obligation remains. And then to think about living under humanitarian law, part of what that is to be a certain sort of subject in relation to that law. So as delimited by humanitarian law and the discourse surrounding it, these subject positions are meant to be partial, limited, and temporary, right? They address only certain aspects of life and often resist consideration of vitality, flourishing, and thriving. But despite these limitations, they structure lives in durable and expansive ways. They shape the claims that people make with and to law, and shape relations, affects, and trajectories far beyond law's formal remit. And there are many, and in fact, proliferating subject positions in this arena. One of the most central ones is the idea of the protected person, which is part of both refugee law and IHL. And if one effect of the practice of humanitarian law is in fact to remove many people from the position of the protected, and in part through a proliferation of categories that does some of this removal. I want to briefly note three key ways in which humanitarian law shapes life and death. decision-making, threat calculation, and conjecture. So to the extent that humanitarian law has governing force, it's less in its capacity to generate sanctions for violation and much more in producing an environment and framework for decision-making. So in combat, targeting is a central decision occasion. Decision-making under humanitarian law directs violence towards some people and places and away from others. And I think we can see that humanitarian law isn't so much just applied as made in these decision-making processes. Given the general absence of external supervisory authority in humanitarian law, there's a kind of circularity in this process. So practitioners, whether lawyers, policymakers, military personnel, make decisions about rules of engagement and targeting in reference to humanitarian law. And those decisions are frequently deemed compliant because of that reference decision-making, not because of the particular decisions that are made. Which doesn't mean, of course, that people, analysts, politicians, and protesters don't talk about violations of IHL and decision outcomes. They definitely do. And such accusations have been a regular and powerful part of public debates about both Israeli and Palestinian action in the past year and before. But nonetheless, the decision-making looms, in some sense, the largest in the practice of law. I should say, in regards to the question of Palestine, there's been a long history of international bodies naming violations and Israeli military and political leaders denying not necessarily the conduct per se, but its legal meaning. And this denial has long been a source of frustration for the International Committee of the Red Cross, which understands itself as the guardian of IHL. And I've been working in the ICRC archives, particularly on the first years of the Israeli occupation. And this record is filled with ICRC efforts to try to encourage a change in Israeli practice and then express frustration about their inability to do so. So this begins from the beginning of the occupation. To turn to the question of threat calculation, I think we want to recognize that humanitarian law centrally involves the management of threat to civilians, to state security, to global order, but not its dissolution or resolution. And humanitarian law is meant to put some guardrails on how threats and people as threats can be contained, but it doesn't really change the calculation that some people, and often their very existence, constitute a threat. And in state responses to perceived threats, there's a tendency to operate kind of just beyond the limits of law. Sometimes through a proliferation of categories, like of persons and situations that enable kind of slippage beyond the constraints of law. So things like, situation of armed conflict short of war, person categories like human shields and unlawful enemy combatants. And then to turn very briefly to conjecture, I think the Palestinian instance reveals with exceptional clarity the tendency of humanitarian law to operate through conjecture. That is, deliberation and discussion about how law might be applied and what might be its effects, with decisions that are conditional in multiple ways. There's kind of a negative expansion that happens where acting in seemingly flagrant violation of law can work to expand permissibility under the law and the generation of new legal frameworks rather than actually triggering enforcement of existing law. Israeli practices of denying protected civilian status to people who do not heed warnings to leave buildings or areas, calling them voluntary human shields, is one instance of such boundary pushing. I think the current war in Gaza highlights the profound limits of humanitarian law, not just in its cynical manipulation by the powerful to avoid constraint, though there's plenty of that, but in the very structure and practice of this law itself. So indeterminacy, fuzzy logics, conjecture, proliferation of ever-shifting status categories, they all contribute to the ways that this law, which is meant in part to offer protection, in fact, often increases vulnerability. Which I think highlights the limits of humanitarian law as a site to seek solutions to the problems it addresses. Ending the suffering in Gaza will require political decisions, not simply legal maneuvering. and ultimately getting to a better future for everyone in Israel and Palestine is going to require dramatically new political thinking and action. And I think, having already spoken for longer than I intended, I will stop there and look forward to the conversation.
Thank you so much, Ilana. We do live on opposite sides of the country, so it's nice to have this opportunity to discuss some of our mutual areas of research or common areas of research. And I want to thank the Crown Center for this invitation. So I'll just start with a few questions that have come up in this brief essay that I know is part of a much longer work. So let's just get a sense of what you mean, if we can, of the subject positions that are being created. You kind of talked about some of the statuses that are created, but one thing I notice is that, as you note, with IHL, they're partial, they're limited, and they're temporary, but you also note that they structure lives in very durable ways. So is this a contradiction in terms? And could you give us this deeper sense of what you mean by the structuring effects?
Thanks for the question. And in some sense, I think the answer to any question about contradiction in terms is always going to be yes. But that is part, I think, of the structure, right? That the nature of humanitarian law has some internal contradictions built into it. And one of them is that it's meant to have a limited remit, be applicable to limited situations, and speak to limited aspects of people's lives, right? So, in some sense, the things that become relevant to the situation at hand, but extend beyond those situations, and then the recognition, the way people are recognized by humanitarian law, even as very frequently that recognition doesn't accomplish the aims that it is meant to, has enduring effects. So let me say what I mean by that. So and maybe starting with the category refugee, which is something that I've spent a great deal of time working on. So recognition as a refugee is meant to provide people, again, depending on the circumstances, with various things. In the Palestinian instance, it was meant to be a means for providing people with humanitarian assistance. So it was an assistance definition. In the broader refugee regime, international refugee regime, refugee law regime, a key thing that it is meant to provide people with is protection. And over time, the Palestinian refugee institutions have taken up protection as part of their mandate, but initially there was a real distinction that the Palestinian refugee was a means of access to assistance, and the 51 convention, the international refugee, is yes assistance, but first protection. We know that in both the case of Palestine and more generally, frequently protection is denied, is not available through circumstances that make it impossible to enact, through mechanisms of distinction that actually keep people out of the category of refugee, even as their circumstances are, in terms of the kind of vulnerabilities and displacement that they experience, look on the face of it like that of the refugee. So one of the ways in which the sort of failure to accomplish the purpose is by limiting access to the category that's meant to offer that. But also within the category, there are all sorts of structuring limits. In the case of Palestinians, particularly again in the early years where the focus was on assistance, from the very, very beginning of the establishment of a humanitarian assistance regime for Palestinians, there was a recognition that the categories being deployed were not adequate to the needs that people were experiencing as a result of both the displacement and dispossession of 1948. So and here it was, to be recognized as a Palestine refugee, one needed to be both displaced and dispossessed. In Gaza, for example, most of the native population, there was about 80,000 people who were native to the area that became the Gaza Strip. And again, about 200,000 people who came in as refugees. Most of the native population was dispossessed of their land, and therefore, which was their income, used for farming. So in terms of the question of need and disruption, life and vulnerability, precarity as a result of 1948, they were equally exposed, but didn't fit the category. So all that is on the ways in which these categories, which are meant to accomplish limited but significant aims, frequently fail to do so. But then to the other side of the question, what is it that they do in shaping lives in durable ways? Again, I'll continue with thinking about the refugee category and in the Palestinian instance, and actually say that the research that I did that led to the book Life Lived in Relief emerged out of a very kind of concrete ethnographic or just observation from spending time in Gaza doing research for my first two books about how important, sociologically important, the categories refugee and native were to shaping how people interacted with each other, how they understood each other, their kind of social networks, not meaning that it was an absolute barrier to connection, but those categories were live social categories in a way that they are not in the same way in the West Bank for people. I mean, they continue to matter very much politically, but they had a different life, beyond the question of camp residence in Gaza. So really the first nibble of a question that led to this research project was to understand how these categories, which again were established with a particular and limited purpose in mind, came to be so shaping for people, which then again ultimately led to this project. But one of the things that we see is, one, so what has the refugee category, the status of refugee, come to mean for Palestinians beyond the confines of the institutional framework for defining it? It becomes a framework for understanding and engaging in politics, which again is, in some sense, is not just not taken up in the formal area of the category, but is meant to be antithetical to it. The humanitarian categories are not meant to be grounds for politics, but it becomes a grounds for naming historical injustice, for making claims, for mobilizing recognition. And I think the importance of refugee identity and the refugee category for that is one reason it has been so attacked, right? There is an effort by Israel, by many in the United States, and this long precedes the current conflict, to eviscerate the category of a Palestine refugee, precisely because of it, the way that it has been politically significant to people. It comes to be a way of shaping community relations, partly through, and sometimes through the services and institutions that people are a part of through their recognition as this category, in very quotidian ways can shape social dynamics. And again, thinking back to an earlier period where there was a much more broader rations regime, the kind of kitchens where people would gather to receive breakfast rations shaped the daily rhythm of life for them, but also social dynamics, among in refugee communities. And I'll just note, but I won't say more about because I've already given a very long answer to your question. The refugee camp as an infrastructural space to house, again, with a vision of it being limited in time and limited in significance, has been a site and setting for an incredible amount of transgenerational life making. And so one could think about other categories that are produced through different aspects of humanitarian law in similar ways. But but I think they all have effects that are in no ways contained by their sort of founding imagination and are sometimes very much at odds with it.
Thank you so much. I know we have limited time, but this is a great opportunity for people to learn more about your research and how this picture emerges in the context of Palestinian refugees. And, you know, the Israel-Palestine crisis is one of the most enduring. And I was wondering if the generative powers of law and the governing force of IHL and the laws of armed conflict, as well as refugee law that you lay out, is kind of a larger picture? Is it kind of like a lab of, a sort of lab for a larger understanding of international humanitarian law? So just, there today, by the end of 2024, the UN predicts there will be over 120 million forced migrants in the world. And 66% of these are in 55 distinct protracted situations, protracted being defined as a situation of 25,000 people or more without a durable solution for over 5 years. The average number for the protracted situations is now 26 years. So on the one hand, we're dealing with this idea of like temporary emergency protection of IHL. And yet we're really looking at people living under this regime of power, of life-defining force for generations. So could you talk about this disconnect, maybe in the camps, in your own research that you saw? What does this mean beyond that even? On the one hand, we have an enduring presence presided over by laws meant for temporary crisis situations.
Yeah, thank you. And this is an issue. Actually, this would come up a lot when I was applying for grant funding to do my research. Palestine is often thought of as the exception to whatever, right? And it's not the only place that is often dealt with in kind of exceptionalist lens, meaning it's not comparable to anything else. It doesn't have lessons to teach us about any other kind of circumstance. I think this is quite wrong-headed. I think I suspect everybody who works on Palestine have it as a general mission to de-exceptionalize. But one of the comments that I would sometimes get back is, why, if you're trying to understand humanitarianism as an international force, that Palestine is not a good case to look at it but precisely because of its longevity, because this, people are not about to go home. It just goes on, and therefore it's really distinctive. But as you point out, in fact, what is the norm in displacement is protracted displacement. And what is the norm in humanitarian response is engaging with situations that do not fit comfortably into the mandate of humanitarian organizations, right? So this is back to, I think I'm going to say again, your first question asked about a contradiction in terms, and I said my answer was always going to be like, yes. So here's another contradiction in terms that's built into what humanitarian aid, that it is intended to be short-term, crisis-driven, stopgap, filling the gaps of, where they're failing because states are failing, or there's conflict that makes it impossible for the normal institutions that help sustain people to operate. And yet, a circumstance that is a short-term crisis that is quickly resolved in some manner and returns people to normal conditions, that is much more the exception than the norm. The norm is that humanitarian organizations who were built for crisis have to deal with what I call in the Palestinian case, kind of the chronic and, the cruddy, right? The ongoing condition of displacement. So if we want to understand how do international humanitarian organizations or the kind of global humanitarian scene, because there are also, of course, many local humanitarian organizations, but how do humanitarian organizations grapple with longevity, grapple with things like dealing with people who are suffering from illnesses of old age, right, which are not part of a humanitarian mandate. Humanitarian mandate is meant to deal with things like people who risk starvation because their food sources are disrupted, people who are at risk from violence and we can remove them from them. The idea of dealing with diabetes and hypertension as people, reach older stages of life doesn't fit into the vision and the mandate of humanitarian work. But that's what humanitarians have to grapple with as they're dealing with both multi-generational but multi-year forms of displacement. And so I think the Palestinian instance is actually a really crucial one for us to, by studying empirically how humanitarian organizations have grappled with all of these challenges over 75 years. In the Palestinian case, we can understand something about how it is that humanitarians grapple inconclusively and uncomfortably with this persistent contradiction between their actual mandate and what they think their mandate is, right? The actual necessity of their work and how they envision it. And then just one other related aspect of this, the way that I think that the Palestinian case is such a analytically useful one is that it has basically Palestinian displacement, and it is tragic, but then it gives us analytic material to work with. The Palestinian displacement experience has basically been for the full time of the post-war international refugee regime and developing humanitarian assistance apparatus. So all of the kinds of debates and discussions and changes in ideas about best practices, what is, should you give people money and let them then meet their needs with that money? Should you give them goods? All of these kinds of debates that are an ongoing part of the humanitarian system. The Palestinian population has experienced all of them, and humanitarian actors providing aid to Palestinians have worked through all of this with this population. So if you want to track what has humanitarianism been in the past 75 years, the Palestinian instance is a really good place to look for that.
Thank you so much. I mean, I understand the point of view that you're offering. It's a really good place to look at the effects on humanitarians. I also want to know, how does it affect the people who are in the so-called protected status? How does it affect their worldview, their interests, their livelihoods, their hopes and dreams for the future? And the reason I say this is because there's really a parallel world that exists for people living in humanitarian conditions who are not in the Palestinian context and the Palestinians. Often we think there are these three durable solutions that they, return, they're repatriated, they're integrated into the local communities, just, where they're seeking shelter, or they're resettled. In my practice as a refugee lawyer, I knew that Palestinians were one population who could not avail themselves of the laws, the 1951 convention, the forms of relief that are offered, and hence these so-called durable solutions. And so knowing that, it must have some kinds of effects on the people who are on the ground. And I know it did when I tried to present clients from Palestine. So how do you see that? And I guess this is kind of an invitation to say a little bit more about the anthropological lens that you offer. There are so many lawyers and other kinds of views on international humanitarian law, but in your abstract to this talk, you mentioned that you bring an anthropological lens, and I wonder if you could say something about what that brings, and maybe this might have some implications for policy and policy making.
Here, maybe I'll try to talk a little bit about the refugee matters that we've been talking about, but also the IHL question of the kind of conduct of warfare as well. In some ways it goes back to what we were talking, your first question about the ways in which the categories shape people's lives, because I do think one of the things that an anthropological lens brings to investigating these questions is that we are not able to, and therefore it is the benefit of thinking anthropologically, put aside the things that don't fit the structure of the law, right? So from a strictly legal perspective, perhaps you might say this claim that you're trying to make as a refugee, or this claim that you're trying to make as part of a population under attack, doesn't fit the definitions that that have been elaborated by the law. So we don't have a mechanism to acknowledge your claim in the law. What refugees and populations under attack will do and say, not even so much directly to this, but in their life, is to not be burdened fully by those limits, to make of the categories something close, that helps them articulate what are their needs and demands, which can have the impact of ultimately reshaping law, because whatever lawyers may say about clear limits to legal definitions and legal mandates, jurisdictions, as we know, law is alive, and it is alive through its practice, and especially this is something that I referenced in my opening comments, especially in something like international humanitarian law, where there really isn't a enforcing mechanism to kind of settle questions. Yes, there's the International Criminal Court, there's the International Court of Justice. Those are all we see in the current moment, just quite concretely, the limits of those institutions and their capacity to act, but they're also not the primary places where this law lives. It lives in its life, right? And one of the ways that it lives in its life is through militaries reshaping it by doing things that seem to be in violation of the law, but by creating a category of, as I said, of people and situations to provide a legal framework. So, belligerents change the law through their practice of the law, and so do, with less power, less capacity to be heard, and certainly less might, but so do refugees and populations under attack by insisting on, in fact, for Palestinian refugees, the question of return has been at the center of a kind of refugee discourse, and not both as a desire, but as a claimed and articulated right. And this is an effort to push the boundaries of the legal framework, to gain recognition of that. And while obviously we're not, that has not come to fruition, it is remarkable how present that conversation and the articulation of that demand, and that demand as articulated as a right, with reference to international instruments like UN resolutions, things like that, has remained part of public conversation. And that is an effect of people acting through the law, with the law, but not fully confined by the limits that the law declares. I think I maybe wandered away from the anthropological, but
Well, okay, so if we're seeing this in action, and you mentioned the advisory nature of the ICJ's decision, are there any sort of impacts for policymakers or people who are interested in sort of advancing some kind of jurisdiction on the limits of sort of international warfare? You know, I guess I'm just wondering what does all of this say about the ends that are served by IHL? You know, what can we say about sort of the, let me say it another way. Is the Palestinian situation an exceptional inapplication of the laws of armed conflict, the laws of occupation, or is this an exception that makes the rule? And I guess, you know, as you noted in your I think in the abstract, that there's a way in which these laws are reconfiguring colonial and imperial violence. So who is the law for? Who does it serve in the end? And don't forget, if you have any policy suggestions.
so this, thank you. That we'll probably have to continue this conversation. But one of the things I think we're in a moment, and many people have commented that this current moment presents a real crisis for the idea of an international legal order that structures, delimits, again, put some guardrails on the violence of warfare, and that the seeming vast gap between the kind of statements and interpretations by legal authorities, whether it's the International Court of Justice or the ICC, or the many bodies that NGOs and the ICRC that have a responsibility to observe and comment on the violations of international law. Sort of the massive gap between all of that speaking about violation and the absolute failure for there to be a change in U.S. policy, change in kind of global policy based on that, seems to present a crisis of impotence. That is, if international humanitarian law can have no effect, then it may no longer serve to limit people's actions. But then behind that, so impotence is one way to read it. But in your question, I think is another kind of critique is not impotent, but malevolent, right? Should we view international humanitarian law as a means of simply providing cover for powerful states to do what they want and claim justification for it by reference to international law? And actually, I don't think it's any one single thing. I think there are multiple things. There certainly is a long history of the kind of colonial origins and kind of structure of the law, which it's often, I feel like sometimes in discussions, what people say is, the powerful feel that the law doesn't apply to them. But actually, in relation to international humanitarian law, that particularly in regards to the law of armed conflict and warfare, I think actually what people are saying is the law doesn't apply to them. That is, it doesn't apply to our enemies. So they are not protected. We do not have to limit our violence when we are fighting those to whom the law does not apply. So it's a way of sort of having your cake and eating it too. We are law abiding. The law does apply to us. We govern ourselves by this law, but our enemies, it does not apply to them. And so things that look like violations are not violations because they're being enacted against people to whom the law does not apply. And that is there's obviously a current politics that leads to those judgments, but it's absolutely rooted in the colonial origins of international law, not just international humanitarian law, international law more generally, which said that law applies to the civilized alone and not to others. So now to try to think more in a more policy way, and taking the policy notion very broadly, like, what do we do? One, I think for publics, I think, and this is where I sort of ended my opening comments, we need to recognize that IHL or the law in general, it will not be the mechanism, the sole mechanism to a solution. Placing too much hope in what the law can do, what a judgment by the International Criminal Court can do, what a judgment by the International Court of Justice can do, will lead to perpetual disappointment and failure, which does not mean that people should not, just like refugees and people under attack, make use of the law. That doesn't mean that, I think that, global publics need to as well, but need to recognize that the law can only be a limited tool as part of a broader kind of political effort to change the terms of discourse. But I do think for the United States, for powerful countries, that this is a moment where people need to, and I see no evidence that any of this thinking will happen. But I think there is a danger in continuing with this, what seems like increasingly flagrant disregard of a legal order for the case of Israel, for the case of Palestine. This is going to have very significant consequences down the road. And we have a history of seeing the ways in which, for example, around the question of occupation, that as the refusal to accede to some of the structures of IHL that were meant to provide, and I won't get into the details here because it would be far too long, but the possibility of a substitute protecting power to have some kind of authority position over the exercise of the occupation. That was, as the Geneva Conventions were established, seen as a really crucial mechanism. And it's basically never been enacted. And Israel, and the refusal in the context of the occupation of the West Bank and Gaza was, I think, a crucial moment in basically kind of disappearing it from the discussion of occupation, which I think limits the capacity of the international community to respond effectively, not just to the question of the Palestinian occupied territories, but the Russian occupation of Crimea. Right, we have very few tools to effectively respond as international community, always in many scare quotes. But I think taking a serious look at the downstream consequences of current policy decisions would be really important.
Thank you. And I think one of the things that your response lays bare is the limits of depending on solely legal instruments, especially for very complex political issues. So with this, I'd like to turn to the questions. We have a number of questions, and I'll just start with really the first one that does build on the question of legal terms that are being used and your own legal term. This is from Steve and Gail Gerzoff. The speaker framed their comments under the Israel war on Gaza. So can you say more why you use that terminology?
Well, in terms of thinking about the conflict, there is Israel is currently attacking, engaging in warfare in and on the Gaza Strip. And I should say, in relation to the question of international humanitarian law and the question of warfare, there are two aspects to this law. One, a question, one area of law that governs the question of whether or not war is justified. And that is a separate question from the conduct of war. So a war that is justified, and Israel's responding to an attack on its territory and its people, a war that is justified is not released from the obligations of the conduct of war under international humanitarian law. And that's, I think from a legal perspective, it's very important to keep them separate. Because, I mean, you could imagine, otherwise you could end up in a kind of, again, paradoxical situation where a non-justified war has no law that governs it, because if they're tied together in that way, you have nothing that limits the force of violence in a non-justified war. But a war that is justified continues to need, from an IHL perspective, to operate according to the laws of war. But as we see that, that is really these principles are clear in one kind of level of articulation, but very, very fuzzy in practice.
Thank you so much. I also wanted to ask, and this is from Ian Vandermeulen. So I'll just read what Ian wrote. Thank you for this thought-provoking and timely conversation, Ilana. In your first two books, you focus on enactments of power through bureaucratic governance and policing. But in your last book puts the long-standing archival work in conversation with refugee lives. So through ethnography at camps and in multiple countries. So can you elaborate on how humanitarian law and other structures of aid provision shape lives of refugees in those spaces? You spoke of this a little bit earlier, but how do you navigate a sympathetic view of those lives to show some glimmer of them flourishing, your quotes, I think, without normalizing those conditions of life that are meant to be temporary?
Thank you. That's a great question and a challenging question. And actually it brings us back to the anthropological, which I know, Arzoo, you wanted to talk about. And again, I think this is always one of the challenges, and I'll start with a more general kind of reflection on anthropological work, or not only anthropological work, but when you're working on situations and circumstances where people are suffering or deprived or experiencing vulnerability and precarity. I think we have a tension in our modes of attention and our modes of description between wanting to articulate the sort of, in some sense, what is being done to people. That is, what are the circumstances to highlight those vulnerabilities and that suffering, and wanting to highlight what is and sometimes talked about as resistance, or to highlight some other kind of experience, right? A more positive, the kind of agentive response to those experiences. And in point of fact, I think what we need to do is find some way to capture both things, because the circumstances shape what people do with their lives. And so we have to capture and describe them. And at the same time, I think what what we see, and certainly, what I saw in my research, in, again, these kind of extended refugee camps, is that no matter what the circumstances of people's lives are, they are seeking to flourish, right? There are many impediments to that flourishing. But to not give account of that is also to not give a sort of rigorous account of what people's lives are. And this very often structures the relationships that people have with humanitarian institutions, with each other, is actually, I think, that the living in that tension between structural and sometimes targeted, impediment, right? Constraint and limitation, and the effort to do something else with their circumstances. And especially when you're talking about long-term displacement, to imagine and generate the possibility for different kind of lives for their children, right? So, in sort of multi-generational displacement, which, again, as you note, Arzoo, this is not in any way unique to the Palestinian circumstance. Both extended displacement and multi-generational displacement, and also multi-generational, sort of recognition by humanitarian organizations of refugee status. But then, sort of the last part of the question about trying not to normalize the conditions of life that are meant to be temporary. Here, I actually think that the analytic, or the anthropological, the scholarly challenge is an absolute parallel, or goes along in tandem with the very challenge of living in these conditions. Because for Palestinians, or again for others as well, but the instance that I know the best is the Palestinian instance, for people who are living in displacement over decades, they too want to resist the normalization, the permanence of their displacement, and at the same time, in order to both survive and live and seek some flourishing, they do participate in its normalization in some sense, right? It is impossible to fully refuse that kind of regularizing of an experience that you want to reject, and that you want to end. And I think this has actually been one of the central tensions in the Palestinian refugee experience, both at a kind of political sense, like in terms of articulating, what is the meaning of camps? What is the meaning of displacement? How should refugees live? But also at very personal levels, as I'm thinking about, conversations I had with people over the course of my research, where, one person said, this was an instance of a family who were made refugees to the West Bank in 1948, and then displaced again to Jordan in 1967. And a relatively young man saying, my father would say, like, we're not going to buy a car. We're not going to do anything here in Jordan that settles us in here, because then we're not ready to return. But as time goes on, as generations goes on, that people can't live. They may have a political claim, but they can't live so lightly in the places where they live for decades and generations. And the humanitarian apparatus insists that they live lightly. Host countries want to insist that they live lightly. Political movements want to insist that they live lightly, but people can't live lightly, right? In order to live, you have to live more robustly. And so people themselves are always existing in that tension. And so I think the best thing that an anthropologist can do is capture that and describe that. And that's what I've tried to do.
And you've done it brilliantly, I should add. So I just want to say to the questioners, there are amazing questions. We don't have tons of time, so I'm going to try to go as fast as I can, and maybe ask Ilana to be a little bit more, precise. There are some provocative questions, and I would love to ask some of those as well. So I'm going to try to do my best, but building just because Amy Singer's question really builds on the conversation that this last question started. So the question is that displacement has a very long history as a human phenomenon, perhaps even a phenomenon that all human beings have experienced. Humanitarianism, on the other hand, is a relatively recent, historically speaking, response to human displacement. So if you accept this distinction she's making, is it conceivable then that humanitarianism was a conjunctural response, which is no longer effective in sort of a global society of changed circumstances? What do you think about that? That's a great question.
It is a great question. And you want me to be concise. So, I mean, I think, yeah, one of the things, there's of course a massive scholarly debate about the origins of humanitarianism. What does it emerge from? What are its kind of key structuring principles? I think without going into all of that, I think two key things that are part of kind of humanitarianism as it's evolved are, one, a kind of the recognition of the possibility and the frequent actuality of suffering across difference, across the human experience, that there is something shared in humanity in the possibility for suffering. And this is the second point, that there is the possibility and therefore potentially the obligation to do something to mitigate that suffering. So it's a kind of double part thing, which is, recognition and the possibility and responsibility for change. And I do think, the structure of the current moment, even as the discourse of humanitarianism, I think has never been more powerful. That is, in a way that actually has elided other frameworks for talking about connection across difference and talking about mutual responsibility. So when we see circumstances of violence, of need, of deprivation, we think there is, the humanitarian framework is the one most often drawn on to frame how we interpret what's going on and what kind of response is necessary. So that in and of itself is a problem, because there are not every circumstance is best suited for that framework, and we risk missing other crucial ways to think about the question of what do we owe one another, and also what are the circumstances in which we find ourselves. So there is another tension or kind of contradiction, in fact, between this kind of suffusing of everything with the humanitarian, with what I think is pointed to in the question, a seeming increasing incapacity of humanitarian instruments, whether those are legal instruments or institutional instruments, to respond effectively, even in their own terms. I mean, I guess it's the question is sort of the parallel question to IHL in terms of the conduct of war. Like, are we in a moment where the system is collapsing upon itself? And I'm going to have a cop-out answer of maybe, but the question is, what do we need to bring to bear to thinking about, not how do we save humanitarian law or humanitarian institutions, right? Those are products of an effort to actually, I think, ask a series of more fundamental underlying questions. One, as I said, is what do we owe each other? And also, what is our responsibility, a global responsibility in the face of violence of many kinds? How do we as a species want to respond to and engage with that kind of fact of human life? And whether, our current instruments, IHL, refugee law, institutions do not seem up to the task. But right now, I think I mean, here's going to sound really gloomy. Right now, we don't seem up to the task. So we need to, as a species. And so I think that's the effort that needs to be made. What do we need to better address these kind of underlying questions?
Oh, thank you for that. You know, thinking about our discussion earlier, your brief sort of opening, you talked about the generative quality of IHL. And so one anonymous attendee asks, with this protracted refugee situation and others with protracted refugee situations generally, how has the IHL evolved to cope with the legal status of the children of refugees, their status when they come of age, and then the status of their children? So given this generational quality, can you say more about the generative aspects of status making that the law contains?
And this is an area where frequently the Palestinian instance is held out as an exception when it's really not. So, you know, under the UNHCR, which is the institutional framework for refugee recognition for most of the world's refugees, the children of those who were personally displaced, who are born into displacement, are recognized as refugees. So, you know, so you frequently hear in public discussion that, you know, that the problem with the Palestine refugee definition is that it extends this status to future generations. But again, that is not actually a unique or distinctive feature. It is meant to end with resolution. But it has been, I mean, and this was something that UNRWA grappled with. And again, so to note something that I mentioned before, but that is a clear distinction between the two definitions. The broader 1951 convention, UNHCR convention, is focused first on the question of protection, and then, you know, assistance comes along with that. The UNRWA definition was fully about assistance. There was meant to be another UN body, the UN Conciliation Commission for Palestine, that was meant to address protection, resolution kinds of questions, and it was never able to be effective or do anything. It has never been disbanded in a, I guess, typical kind of UN way. But the UNRWA definition was wholly about, in its early days, the question of who would get assistance. And here you immediately come up against the limits of resources, right? The amount of assistance that is available is limited to the resources that UNRWA has at its disposal, which are, you know, donations by, you know, contributions by UN member states. So from the very beginning, UNRWA has been very concerned with, they had ration ceilings, you know, in the days when all refugees were receiving rations, there was a limit to the number of people who could be on the ration rolls, who could be registered as refugees. So even people who fit the category, once the ceiling was hit, couldn't be registered. So this quickly became a practical problem as children were born who had immediate needs, right? Needs for healthcare, needs for support. But if their birth went above the rations level, they couldn't be incorporated. And so this challenge of dealing with both an extended population, but a growing population and really limited resources was a major, major challenge for UNRWA for decades. You know, in more recent times, the actual practical services that one gets as a recognized refugee are much, much more limited. So even though UNRWA's resource challenges have not gone away, the questions aren't posed, and so most people don't get rations from UNRWA, so it doesn't have the same kind of issue. But this is all worked out at the operational level. So not at, at the broad, there is like a kind of standing definition, but that definition was given life by operational decisions and rules about who do you register. So the category exists over here, but lots of people who fit the category can't be registered, right? And making decisions about who you register. So in fact, somebody mentioned my work on bureaucracy. It is in the bureaucratic operations where these things are given life and where the challenges of longevity, the challenges of generations are sort of worked out.
Thank you so much. So we have just a few more minutes, and there are a lot of questions that are really kind of legalistic about the laws of war. So because they're questions really kind of, I would say, on opposite ends of the sort of political and ideological spectrum, there's one about the what is the underlying. I'm going to ask you two questions that I think that are coming from very different perspectives, but I think they're fair questions. One is about what is at the kind of core resistance of the enforcement of IHL. Is it because it's basically settler colonial law, or is an U.S. backing, or is it because of the initial Hamas attack? And if you could kind of speak to the idea of resistance in the context of occupation. That's one question. And the other question, I think, is a bit more clear cut, and it's about the use of human shields, because both sides have now been proclaimed to be using human shields. So could you speak about that? And I know that in your work, you reference the work of Neve Gordon, who has written about that. So those are just kind of two more legalistic questions that I think are coming from a range of viewpoints. Thank you. And we have 1 minute. So
Just because, so the question about the legality of resistance under conditions of occupation. So again, this is an issue in international law, but partly in bodies of international law that not all parties have signed on to. So beyond the 49 conventions, especially in the 77 protocols, there's particularly articulated rights of resistance to colonialism, to occupation. I should say that just as a war that is justified does not relieve one of the obligations to conduct that war according to the laws of war, nothing about a right to resistance relieves one of the obligations to engage in that resistance in a legal manner. So there are aspects of Palestinian resistance to Israeli occupation that fit the requirements of international humanitarian law, and aspects that don't. Attacking civilians is a violation of international humanitarian law. So the fact of having a recognition of one's right to resist does not give one the right by law to violate the laws of war. They are meant to be non-reciprocal. And I think, there's a limited capacity to enforce that, but that is to me is one of the most powerful parts of it, that says you do not get to say the damage done to me by this occupation is so great that there are no limits on my action. You do not get to say that the trauma of these horrific attacks on civilians is so great that nothing will restrain me. The international humanitarian law is meant to restrain us all, whatever the righteousness of our positions, and that is powerful with enormous limits in its capacity to exercise that power. And since over time, I will, on the question of human shields, I will point everybody to the work of Neve Gordon, which is and Nicola Perugini. They've written these things together. And it's a status category that really highlights some of the limits, again, the limits of the capacity of humanitarian law to do some of the things that we might think it is going to do, because human shields are targetable by under the terms of international humanitarian law. And that may not, I think to many that seems a negative outcome, right? That people who are being conscripted, against their will into vulnerability, that they should be targetable by the terms of that war, by the terms of law, does not seem like a right outcome. So again, it highlights for us the limits of the framework of international humanitarian law itself to do all that people might want in envisioning a different expression of violence and a different future and a different way of thinking about, again, what do we owe one another?
Well, thank you so much, Ilana, Arzoo. This was I wish we had another hour. This was a wonderful conversation, and that really drew out the significance, the challenges, many of the contradictions kind of inherent in humanitarian law, and it's given us quite a lot to think about. So thank you both so much for making this possible. I want to let everyone know that if your question wasn't read, we will be sending a complete list of the questions to our participants today. Our next seminar will be on January 22nd with Candace Lukasik, Assistant Professor of Religion and Anthropology at Mississippi State University and a Crown Fellow. She will be talking about her new book, Martyrs and Migrants, Coptic Christians and the Persecution of Politics of the U.S. Empire. We look forward to seeing you at our next event. Thank you very much. Bye now.